Hello, this is Deborah Gonzalez and you're here at Solo Practice University. We are doing the course Intellectual Property, and today's session deals with trademarks, trade dress, and service marks. You do have the handouts right off the website, so please make sure to download them so that you can follow along with this recorded session. As always, we begin with our disclaimer that this presentation is for educational purposes only and should not be construed as legal advice. It is recommended that you seek legal counsel if you have a particular matter, and if you are not a practicing trademark attorney, do make sure that at least with your first case, if this is an area that you're interested in, that you do partner up with an experienced trademark attorney to make sure that you are following all the procedures that are required. In addition, you're going to find that this handout in this recorded session, I do show particular examples of trademark logos, and those are being used under the fair use doctrine for educational purposes only. Okay. So, what we're going to try to do today, and it's a pretty comprehensive session, is to go over the definition and history of trademarks and trademark laws. We're going to look at the concept of distinctiveness and the 5 types of trademarks that there are. We will also look at the process of going through a trademark application and registration. We'll look at issues such as the loss of trademark rights and infringement, as well as dilution of the value of a trademark. And we're going to finish up with certain remedies that are available for you and your clients, as well as look at how the issue of trademark connects with the online world, specifically through domain names. Okay? So let's begin. We're going to start with the definition that the U.S. Patent and Trademark Office actually gives us to let us know exactly what is a trademark. And I quote, "A trademark is a brand name. A trademark or service mark includes any word, name, symbol, device, or any combination used or intended to be used to identify and distinguish the goods, services of one seller or provider from those of others, and to indicate the source of goods or services." Okay, so one of the most important things here is the idea that the trademark, that mark, is used to identify a source and to distinguish that source from all others. Now, the U.S. law that controls trademark is called the Lanham Act, and it is the U.S. Code Title 15, okay? And it not only governs trademark, but you're going to see it also has that subtitle of saying that it governs trademark and unfair competition. And that's because trademark is really focused on what is happening in commerce, what's happening in the marketplace. So this is a very business type of value of intellectual property. You do have a site there. This is the BitLaw website, and the reason why I like this one, if you're new to the Lanham Act, is that it really breaks it down by each section and sort of gives a little annotated piece for you. So if this is new for you, trademark, this is a great website to start with, and you do have the URL, the address to get to it, right in your handouts. So the next thing is, let's take a look at some examples of trademarks. And some of these are going to be very familiar to you. So things like Mickey Mouse and the Batman sign, the Coca-Cola. And here what's interesting about Coca-Cola, as we're going to see, it's not just the markings, but even the bottle itself is trademark. And we're going to look at that in a little bit. This is the NBC Peacock, and of course, McDonald's Golden Arches, okay? Now, these are examples of trademark. They're identifying goods. The difference with the service mark is that it identifies a source for services only. So here are some examples. Here we see crime solvers, right? And even though it has the graphic of sort of like this Sherlock Holmes, you get a sense of exactly what it is that they do. They're not offering you a product, they're offering you a service. Here's one that's more in the nonprofit sector. Give us your 2 cents, we'll give you change. Okay, so it's emphasizing what it is that they do. So that's the difference between a service mark and a trademark. Okay, so now that we have a sense of what trademark, service mark are, let's look at some of its history, because it's really interesting. From the very, very ancient civilizations, there's always been this tendency, this part of us that says we want to mark something to show that either we own it or that we created it. Okay, and so we begin back in the Middle East, 3500 BC, with these stone seals that people would make, and they would put it in there. You know, ancient Egyptians, Greeks, the Chinese, even Romans, they would put stamps or markings on things like their brick, their pottery, or for the Romans, for example, they would put markings on the sword so that it was shown which swordsmith had actually created it. It's in the Middle Ages, when we have the European trade guilds, that they start to begin to adopt specific marks to indicate who created what. Okay, and there are some schools and theories of thought that talk about, well, maybe even the coat of arms that were used by some of these families in England are actually a way to indicate a source, can be almost seen as another version or type of trademark. In 1266, we actually start getting the first laws in England, and this is the Baker's Marking Law. And what it was is that it sort of regulated a series of pinpricks that were put into the baked bread to show who or which bakery it actually came from. So it's kind of interesting. It's not a mark in itself, but a series of pinpricks, and that was the way they identified that. In 1618, though, almost 350 years later, we actually get the first improper use of a trademark case in the King's Bench in UK. And this is a case, it's called Southern v. Howe. What's interesting about this case is that it doesn't necessarily talk about a mark that identified a particular source or individual, but it talked about a mark that was indicating whether a product was high quality or low quality. So the case here, we have a plaintiff who's a manufacturer of high quality cloth, and that plaintiff sues a competitor who was using producing lower quality cloth, but using the marking for a higher quality cloth. And this, you know, the idea that it also is misrepresentation to the people who are buying that cloth, okay? So what about that's mainly outside the U.S.? In the U.S., the first instance that we have of a conversation happening around creating a federal trademark law happens in 1791. There was a dispute over sailcloth marks, and Thomas Jefferson really advocated for federal legislation to be able to resolve this issue, but it would not pass at that point. It wouldn't be until 79 years later, in 1870, that we actually get the first U.S. federal trademark legislation. And that same year, in 1870, we also get the first modern federal registered trademark, and that was to Avil Paints, and it was an eagle logo. I searched to see if I can even find an example of that. It is, of course, a dead trademark right now. I could not even find a sample of that. So if any of you ever find a sample of the Avril Paints Eagle logo, please let me know. Okay, and if you want to learn more or get more details on the history of trademark, I've also put in the website so that you can read some more, because there's a lot of details and things, but that gives you the sense of how we got from an ownership mark in trademark to where it's looked at now as really identifying a source in commerce. Now the next probably seminal case for trademark law is the Abercrombie and Fitch versus the Hunting World case, and this was a U.S. Court of Appeals in the Second Circuit in 1976. And this case is important because it actually lays out for us the 5 particular types of trademarks that there can be, and also lays out why each of them may or may not be eligible for protection. So this is a really important case. You have the URL of where to get this information in your handout. So make sure you read the entire case if you're going to be practicing trademark law. So all of these types of marks actually fall within the category of distinctiveness. What makes them different from other types of marks? And it's because of that distinctiveness that then evaluates whether they're protectable or not. So we're going to go through these 5 types of marks, starting with the one that's least protected or no protection at all, getting to the 5th category where there is just about automatic protection. So these 5 marks begin with generic, descriptive, suggestive, arbitrary, and the last one is fanciful. So let's begin with generic. And generic, think of it exactly the way it says. It's something generic. It's something general. Remember, the law is about identifying and distinguishing a source. So something that's generic doesn't do either of those 2 things. So the court here says a generic mark is not eligible for protection, and it really only refers to a class of products, not an individual product, not an individual source, but a class of products. So they give in the case an example of the use of ivory. And if you're saying these are ivory jewelry boxes, the court says that is not enough to distinguish or identify a source, because what that does, it describes the products made from elephant tusk. And so for the court, that was just too generic. Now, the other problem that we have with generics is that a mark that, even though it became registered and protected and seems pretty strong, can actually lose its protection if it becomes too common used in commerce. And this is what we call genericide, okay? And we have some examples. Aspirin was actually a trademark by the Bayer Pharmaceutical Company. And they did such a great job at marketing aspirin that people just began to call every type of medication like that one aspirin, and because of that they actually lost the value of that trademark. So aspirin is no longer trademark. We also have escalator. Escalator was a trademark that was registered and owned by the Otis Elevator Company, and again, because of its common use, they lost the trademark there. And probably one of the most popular marks that became generic is zipper. You probably don't realize, and many people don't realize, that that was actually trademarked by the B.F. Goodrich Company way back when. But, does anybody ever consider paying a royalty when they say zipper? Probably not. Now, because this is such a real issue, we have many companies that will spend millions of dollars trying to protect their brand from becoming too general. And an example of that I've put in your handouts is actually Xerox. Xerox is famous for putting out these kinds of ads in magazines and newspapers where they try to tell people you cannot Xerox a Xerox on a Xerox, but you can copy a document on a Xerox copier. And I just want to read to you the content of their ad. If a trademark is misused, it could come undone. If you didn't know zipper was a trademark, don't worry, it's not, but it used to be. It was lost because people misused the name, and the same could happen to ours, Xerox. Please help us ensure it doesn't. Use Xerox only as an adjective to identify our products and services, such as Xerox copiers, but not as a verb to Xerox, or a noun, Xeroxes. Something to keep in mind that will help us keep it together. Okay, so here, as you see, Xerox knows that the only way that it can keep the value of its trademark is actually if the public, if the market itself helps them distinguish the way that that is being used. So I think it's really interesting, and when you talk to your clients, if they're looking at trademarking a mark, You want to make sure that it's not generic, or that if they do have a mark, you want to protect it from becoming generic. Okay. Our second type of mark is what we call the descriptive mark. And here in U.S. Code Title 15 in Section 1052E1 is the definition for a descriptive mark. And that is if it describes an ingredient, a quality, a characteristic, a function, a feature, a purpose, or use of the relevant good and or service, okay? Now, this is one of those that has a blurry line, because what the court says is that usually if it's just describing, then it's not going to be protectable. It's not going to be eligible for a registered trademark. However, if it has a secondary meaning in the minds of consumers to identify the source, then you have an opportunity to have it protected. So an example that I have here in the handouts would be, for example, Seattle's best coffee. Now think of it, Seattle, you would think, well, that's a geographic name. Best is just giving an adjective of what this coffee is. But when used together, Seattle Best Coffee in the minds of consumers actually identifies to them that that is a particular source in commerce. So another good example that I brought up here, because I thought it was funny as I was doing the research, it's called Excellent Flower Stick. Excellent Flower Stick. So here again, very descriptive, right? Excellent. It's a stick. It's made out of flour. But when used together, it acquires that secondary meaning to identify the source, okay? So our third type of mark is what we call suggestive. And here, unlike the descriptive that describes that feature, here the idea is that the trademark suggests something. So they say, you know, you have to have sort of a little bit of imagination to make the connection between the mark and the service, okay? So the U.S. Patent and Trademark Office says that a suggestive mark requires imagination, thought, and perception to reach a conclusion about the product. Now this one, unlike the generic no protection or the descriptive protection if you have secondary meaning, a suggestive is eligible for protection. And so here are some great examples, and these are stuff that you see all the time. Chicken of the Sea, Gatorade, Greyhound Bus Service, and Citibank Financial Services. Now in your handout, I also brought up these two. This is Duncan Hines Moist Deluxe, and then Betty Crocker Super Moist. And you're going to say, well, wait a minute, they're both using the word moist to describe, right? You would say it describes, does moist describe the cake? But then you have deluxe and super. Does that become the suggestive, okay, of the trademark? Is there trademark infringement here? Would the consumer be confused if they looked at these two boxes? I mean, you've got red, you've got yellow, but then you've got red and you've got yellow there. And the court says no, there is no likelihood of confusion on the part of a consumer, and those are used correctly, each of them on their own. Okay. Our fourth type of mark is what we call the arbitrary mark. And here we have a common word that is actually used in an unfamiliar way. Just like the suggestive, arbitrary marks are also automatically eligible for protection. And some examples are some that are quite familiar to all of us. Apple for computers. Apple is a very common word. It usually refers to a fruit, but the fact that it is now being referred to computers and computer devices and services gives it that arbitrary protection under trademark. Nike for sports-related products. Nike, as a common word, actually refers to a goddess. It is being used in a non or unfamiliar way. Nickelodeon for the television channel. You know, a Nickelodeon is basically a movie theater that used to charge 5 cents. That's where it gets its name, nickel, and then Lodian. But now it's being used in a different way through the television channel. The other thing about arbitrary is that sometimes these trademarks are also acronyms, okay? So an example here would be Qantas, which stands for Queensland and Northern Territory Air Service. So instead of trying to trademark that entire name that's more descriptive, what they used instead was the acronym, and that's what they trademarked, Qantas. Another example is IBM, which stands for International Business Machines. Very descriptive, but when they use the acronym, they can then get the protection of arbitrary. Okay? You have two examples here that I gave you in the handout as well, and the way that they're used in commerce. You have trump. Now, most of the time, an actual person's name is not entitled to protection, but when it's used to acquire a secondary meaning in an unfamiliar way, right? Trump is very common, used in an unfamiliar way, you'll get the protection there. And then jockey as well is being used for the undergarment. So those are two more examples of those arbitrary marks. Our last type of mark that we're going to look at today is what they call the fanciful mark. And a fanciful mark is basically an invented word. It doesn't mean anything except to identify that particular product or service in commerce. And of these, because it is so unique, because it doesn't have any other meaning, these again are entitled to automatic protection under trademark. So here are some examples: Kodak, iPod, Lego, and Verizon. And do remember that when you're looking at trademarks, it's not just the word, but it's also the way the graphic of the word is emphasized. So you see Google, again, a made-up word, but you see the different colors that it uses. Those colors, those graphical elements also lend to the strength of a mark. Lego, the eBay, and even Skype. So I wanted to show you that distinction between just the word and then the graphical element to it. Okay, so we've seen the 5 different types of marks that we had there, right? And the strength of those marks depending on what category they fit. What I want to do now is go over the actual registration process. And you can do a registration for a trademark at a federal level. You can do a registration for a trademark at a state level, or you cannot register it at all, okay? Which is considered a common law trademark. You're going to see that sometimes clients will ask, well, what about a poor man's copyright or a poor man's trademark? Can't I just, you know, take my mark, put it in an envelope, date it, take it to the post office, have them sign it, and mail it to me? Will that be enough to give me protection? And the issue is, no, that is a myth of that poor man's trademark. It just shows that you used it on that date, but it doesn't prove that it was yours to begin with, okay? Now, what's the difference between a state registration and a federal registration? Some Secretary of States for the different states may offer a service to their business clients to be able to register a trademark for a very low cost. Things start at like $25 and up, and they can do it very simply online. But that only gives them a certain limited amount of protection right there in the state. So if somebody, you know, infringes their trademark or violates their trademark outside of that state, they don't have that much protection. It's not as strong as a federal trademark that you have there. Federal trademarks, and you have the link of where to go online in the U.S. Patent and Trademark Office, are usually about $275 to $375 per class or category. And we're going to take a look at what that means per class or per category. Now, why federal registration? I mean, that's something that your clients may ask. Why don't I just go the cheap route and get a state registration and not a federal one? Well, the federal registration really goes further in helping to protect the brand. Okay, first of all, it gives what is called constructive notice nationwide to the trademark owner's claim. So not just in that state, but all of the 50 states of the United States. It is prima facie evidence of ownership of the trademark for the U.S. courts. It also helps to say that then jurisdiction of federal courts can be invoked in a trademark violation case. Registration, the federal registration of the U.S. can then be used as a basis for obtaining registration in other countries. You can't do that with a state trademark. You can only do that with the federal one. And in fact, registration of a federal trademark can be filed with the U.S. Customs Service to prevent the importation of infringing foreign claims. So those are some very significant benefits to a federal registration if your client is doing a lot of product manufacturing. Okay? Now, the U.S. Patent and Trademark Office actually gives you different options to be able to file a trademark, from paper, so you can actually fill out all the paperwork and then mail it in or take it into the office, or electronically, and it's a lot cheaper to do it electronically and upload your different specimens, and we're going to talk about that in a minute. And so basically there are 4 things that you need to complete the registration process. Number 1 is the application. You need a full application. You need an appropriate fee. You need the drawing of the mark to be registered, and in today's world where everything is electronic, a digital file is the preferred method of uploading what that drawing would look like if it is anything but an unstylized word. So you do have a choice, you do have an option to just trademark words without any graphical images. But the words alone are not as strong a mark as when they do have some kind of graphical element, such as color, lines, drawings, things of that nature. And 4th, you need the specimen of the use of the mark, okay, and its actual use in commerce. Now, the other thing is you can actually file for a trademark for intent to use, meaning that it's not out at the market yet, you're still in development stages, you haven't produced it to market. The issue with that is that if you file a trademark intent to use, when you actually get it to market, you must refile a completely new registration application for use in commerce, okay? So one of the things you have to talk with your clients about is how much time is it going to be in development? Do you need to register intent to use, or can you wait a few months to do the use in commerce? And that all depends on what the particular good or service your client has, what they're trying to protect, and how much competition is out there where they may need to file an intent to use quickly to get some protection because the marketplace is so competitive in that industry that they are in. Okay, so here's the process that I usually use with my clients, and something that I suggest can be a great best practice. Number 1, always do a feasibility search study on the mark itself. And this will help determine the strength of the mark. It will help identify any marks that are out there that are similar, that can then become a challenge to your registration, or any other confusingly similar marks that may already be in existence. It also can let you know whether those other marks are live or dead, or who may be using it. And that way you can really advise your client so they know if there's too many challenges out there, or if the mark that they wanted is already trademarked. That way you can let your client know what they may be faced with, because it's really disheartening to a client that they go through the entire registration process and then they don't get their trademark in the end because there was something out there and it could have been viewed. Now, how you do that study, there are actually some companies out there that will do the study for you. They range anywhere from $300 to $500, and then they give you a full report, or you could do it yourself. It's to look at different databases, federal as well as state, because remember that states do give those trademarks. Google, for example, to see where else that trademark may be used or how it may be used. And there are also all sorts of different databases to really go out there and see whether that mark or something similar is being used, okay? Next step that you have to do is when the client says, I want to get this done, you need some basic information from your client. And one of the most important pieces of information is the first time they use that logo internally, and then the first time they used it publicly. And that public use is what we call the date of first use in commerce. So internally, maybe they have a group of people, they're deciding to put this business together, this product together. They had a brainstorming session, they came up with the logo. That is the first time that they use that logo, right? When they start talking about, this is our logo, this is how we're going to identify ourselves, versus the first use in commerce, the first time they put it on a business card, the first time they put it on a website, the first time that they actually approach a potential client or customer using that logo to identify themselves, okay? So that piece of information is extremely important, okay? Take digital photos, and these digital photos are what are going to be used as specimens. Just like in the Copyright Office, they want deposits of what you are copywriting. In the Trademark Office, they want specimens of how you will use this mark in commerce, okay? So if it's a product, photos of the packaging to show how that product is packaged and put out in the marketplace. If it is a service, a screen capture of that home page to show how it's being used on the website to identify the source, or maybe even how it is used on your marketing materials, brochures, business cards, etc. So it's definitely those types of things that make good for the specimens. One of the other things that to be careful about the specimens, that if you are trademarking a collection, let's say a series of books or a series of DVDs, make sure your specimen is not just of one book or one DVD, but show that your specimens are the collection. So multiple books, multiple DVDs, that's very important, okay? One of the other things that they ask for you when you register is that you register a trademark based on class or territory. Categories. And I put a link there to give you, it'll take you to this Small Firm Services Limited. But what I like is that they give you the description of each class that there is. And so you may have a mark that may need to be registered as a goods, but also as a service. And so you have to make sure that you identify each class that you require. So some examples are Class 2 includes paints, coatings, and pigments. Class 9 includes computer, software, electronic instruments, scientific appliances. Class 14 includes precious metalware and jewelry. Class 38 deals with communication services, and Class 41 includes education, amusement, entertainment, and reproduction. So a lot of television shows and characters would be in that Class 41. So just important to know that you need to know which classes you're going to file, and then that the trademark fee is per class. So if you have 2 classes, then the fee would be $750 if you're filing it online, and it's a $325 fee for each one. If you have 3 classes, then it would be over $1,000. And that's important because if you only send a fee for 1 class, the U.S. Patent and Trademark Office will actually reject the entire application. They won't reject the 2 that you didn't pay for, they'll reject all of it. So you want to be careful about that, and you lose your money. Then you have to refile and repay for all 3 of the classes. So Keep that in mind. Now, you as the attorney, when you're filling out these forms online, you will be required to sign as the attorney and to make the payment, okay, right during that process. And you'll receive an email confirmation and acknowledgement that the application was put through. You'll receive an acknowledgement that your specimens were uploaded if you do this online. Now, one thing to keep in mind is that this process can take anywhere from 3 months to over a year to get through the process. And you know, one thing that I always tell my clients about is that a trademark application is much more complex and sophisticated than a copyright registration. And that's because the U.S. Patent and Trademark Office actually has attorneys on the other side that are looking with a fine-tooth comb at the trademark registration and pulling out, you know, this isn't valid here, this isn't valid here, this isn't valid here. And so it becomes this conversation between two attorneys to try to make this application acceptable to them, okay? The other thing is that that attorney may send you correspondence, and it is very important that you respond in a timely manner. And they usually give you 6 months for a response. I usually don't wait that long. If I get something, I try to respond within a week or 2. And the idea is after those 6 months, the mark is considered abandoned and you have to begin all over again. So you want to make sure you look at that, okay? Now, once you get through that process and the mark is considered approved, you're going to be notified that it is going to be published. And it becomes published to see if there are any challenges against it from outside of the office, okay? And they'll tell you when it is going to be published and where it is going to be published. After the publication, you'll receive an official trademark registration document, and that's where you can start changing that TM in a circle on your logo to an R in a circle. And that R in a circle means that it's registered. When you see a logo and it just says TM in a circle, it's not registered yet, okay? So you want to keep that in mind as well. Now, unlike copyright, which once you file, right, there is no sense of you have to renew it or you have to go back and do more paperwork. With the trademark you do, and there are certain deadlines, 5 years, 8 years, and then every 10 years after that. And the reason that there are these deadlines where you have to file paperwork, and you still have to pay a fee every time you file that paperwork, but it's important because what that paperwork says to the U.S. Patent and Trademark Office is that the mark is still being used in commerce the way that it was being used when it was applied for. And this is the reason why you see a lot of, you know, if you ever do a trademark search in the Trademark Office database, you'll see that there are a lot of marks that are listed as dead, and that's because either it was no longer being used in that way and so nobody did the follow-up, or nobody remembered to do the follow-up, because this is something that you have to remind your clients. They must follow up with this, and if they're not going to continue to use you, or they change from you to another attorney, or they change from another attorney to you, this is one of the items that you have to follow up with your client to see, do they have any trademark registrations, when were they registered, and when is that renewal due, so that they don't lose it. Now, if you've never done a trademark application before, the U.S. Patent and Trademark Office actually has a series of videos on YouTube that you can look at and help you go through the process. So you have that website right here for you to take a look at. Okay, so now that we get a sense of that registration process, then the next question becomes, well, what can we do with it now that we have the trademark registered? Let me just for a moment talk about the scope and enforcement of trademark rights. And here's the thing, just like copyrights, there's no international copyright, there's no international trademark either. And so there are geographic limits to a trademark, meaning that it's basically limited to where the actual use has been established. So it's really important that if you're doing a federal registration, that you sort of emphasize the fact that this is going to be nationwide. The product or the service is really being looked at nationwide. There's the other concept of territoriality, and here we're looking at the issue of the strength of the trademark in the international market, okay? And what we find, since there is no international trademark, but we do find bi and multilateral treaties signed by either two countries or multiple countries that say, you know, we will recognize the trademark of other countries as a starting point for registration in ours. And so we have the World Trade Organization TRIPS agreement, and TRIPS means trade-related aspects of IP rights. So again, if you have clients that have products or services where they're going to have clients or customers that are outside of the US, it is very important that you read the WTO TRIPS agreement and understand what those terms are. You also want to take a look at what countries have what agreements with the US in terms of trademarks and protecting goods and services abroad. Now, there has been what is called the Madrid Protocol that is governed by the World Intellectual Property Organization, or WIPO, W-I-P-O. And what this protocol allows is it allows for you to register a trademark, to start the process of the application and registering a trademark in various countries. I think it's up to over 80 countries right now. One application, one fee. Now you do have to follow up with each of the countries, but it's a great step forward. And in the beginning, the US was not a signatory to this. I'm happy to say that we are a signatory now. So it's something to discuss with your clients as well, is if they are going to offer their product or service overseas, whether they want to look at that Madrid Protocol to begin that process, okay? And you can Google Madrid Protocol, WIPO, and really get more information. Or you might just want to partner with an attorney, a trademark attorney who has some experience with that to sort of get you going in the beginning, okay? Now that you know what your scope is, the other thing that's very big on trademarks is this issue of licensing. Licensing a trademark, because you can basically sell, buy, transfer, or license a trademark. It is a property that your client owns, and so they can do pretty much what they want to do with it. In licensing, we have two particular categories. The first category is what we call conventional licensing, and this includes characters, designs, or trademarks that are used to convey an affiliation for or for aesthetic purposes. So think of, you know, cartoon characters, think of movies, sports teams. Most of these will utilize conventional licensing. The other kind of licensing is what we call brand extension licensing. And here the trademark is a brand that is clear, positive imagery, and it provides a strong fit for a particular product. So you're like lending the value of your brand to another product, okay? And so food, beverages, durable goods, that's where you're going to see that kind of brand extension licensing. Now, I do highlight in your handouts the issue of the Licensing Expo. This is one of the biggest licensing trade shows that they have. It's held in Las Vegas every year. If your client has a property and they're trying to find licensees for that property, it is an interesting place to go. And if you are new in licensing and trademark and all of that, it's also a great place for you to go just to get a sense of what's out there, how people are licensing, the different options that they have, those kinds of things. Now, licensing, you know, the idea, I sell a license, what do you get back if you sell that license, okay? It's the idea that you're going to get a royalty payment back. In other words, every time somebody who's licensed your trademark is using it, you get some money back. And so I just have this simple little sort of three-step arrow that tells you exactly how that process works of you licensing to them and then you or your client getting that money back. Just some interesting stats in terms of licensing. It is a $150 billion worldwide business. 44% of all licensee royalties actually come from character and entertainment properties. So those are really important, things like movies and TVs and animation and all of those things, games, very important. Corporate licensing, number one top category is food and beverage, 31%, apparel, 16%, accessories, 7%. Okay, so you get some very significant statistics there about where that licensing royalty money is coming from. But besides the character and the entertainment properties, a subset of that is sports licensing. Over $707 million in royalty revenues, 14 billion in retail stores, okay? What are the top sports licensing organizations? National Football League, the Major League of Baseball. Collegiate Licensing Company is number 3 in terms of sports licensing, and that takes care of all the branding and trademarks and logos for colleges and universities. So that college football, very, very lucrative. This is where we see the numbers. The National Basketball Association, NASCAR, and National Hockey League. Believe it or not, those are our top contenders for licensing. So you also get some additional information on the URL that's in your handout. So big money. Now one of the problems is that you can go through the registration, you can have your licensing agreements, and lo and behold, you can still lose your trademark. And how do you do that? Basically 3 different ways. Number 1, if you abandon, if you stop using that trademark and you have not used it for at least 3 years, okay, and it comes time for renewal, or somebody challenges that trademark because it has not been used in 3 years, it can be lost due to what is called abandonment, okay? And you will see that in the U.S. Patent and Trademark Office when you do a search, and if it says that the mark is dead, it may also indicate that it has been abandoned, okay? Improper licensing or assignment, or what they call naked licensing or failure to police. It is your job to enforce your trademark rights, and if you do not do that, you can lose it. And the third way to lose your trademark rights is genericide. And we saw this when a trademark, a really strong trademark, then becomes so common in the minds of people, they lose that value. So think of aspirin. Another good one I like to always talk about is rollerblading. There's no such sport as rollerblading. It's actually inline skating. Rollerblades was the first company to come out of it, and they lost their trademark because everybody now calls it rollerblading. Okay, so infringement. Infringement occurs when the court says that a reasonable person standard declares that there is a likelihood of confusion between the 2 marks in the minds of the consumers. Because remember, the mark is about identifying and distinguishing one source from another in the public mind. Now the court in Polaroid Corp., and this is a 1961 case, actually outlines 7 factors to determine the likelihood of confusion. The first factor is the strength of the mark, and that's where they're looking at that distinctiveness, one of those 5 categories from generic to fanciful. It's going to look at the strength of the mark. It's going to look at the proximity of the goods of the 2 marks. So if the one mark is like in airlines and another one is faucet, and the example would be Delta Airlines and Delta Faucets, the courts are going to say, you know, there's not a likelihood of confusion. I mean, one you're going to fly a plane, the other one you're going to pour water out of. So that's not a likelihood of confusion, okay, because the proximity of the goods are not close at all. They'll look at the similarity of the marks, and that includes the colors used in the mark, the graphics used in the mark, the words in the mark. So they're going to look at, well, how similar are they? The fourth factor is there any evidence of actual confusion? Is there, now it would be a Facebook post or an email where a customer says, well, you know, I thought I was buying this, but look, it was actually this mark and not what I thought I was buying. So if there's any evidence of actual confusion. The similarity of marketing channels used. So if they're both using television, or they're both using print, or they're both at a particular trade show trying to market their goods, that's going to add to the likelihood of confusion. The sixth one is the degree of caution exercised by the typical purchaser. So if this is a, a pretty low priced item where consumers are not really going to be that intent on looking at what they're buying, and toothpaste would be an example of that, and they just pull it off, versus something that the purchaser might have to think a little bit before they go ahead and purchase that item. And then the last one is the defendant's intent, and this is really important, whether the defendant, actually went into with the intent of using the mark to not just confuse customers or potential customers or the marketplace, but actually to take advantage of the original mark strength to be able to do that. Now, besides infringement, there's also the case for delusion of the value of trademark, and delusion is any use of the mark that dilutes the distinctive quality of the mark, either through blurring or tarnishment of that mark. Unlike an infringement claim, likelihood of confusion is not necessary. Now, a federal delusion claim can only be brought if the mark is famous. Famous meaning that, people, it is, readily known. It is very common, and we have some factors here from the U.S. Code, section 1125C, that tells us what would make that delusion, that mark famous. So things like the degree of inherent or acquired distinctiveness, the duration and extent of use, the amount of advertising and publicity, the geographic extent of the market, the channels of trade used, the degree of recognition in trading areas, any use of similar marks by third parties. And this is where that federal registration is important, because the number 8 factor is, was the mark registered? So registering the mark can actually prove that it was famous. Now, you can also have a state delusion claim, because remember, we do have state registration. That doesn't matter if it's famous or not. What they're more concerned about, does the mark have selling power, a distinctive quality, and are the two marks substantially similar? So a lower burden of proof, right, for the state mark. But then remember that that federal mark has so many additional benefits. Now, besides an infringement or delusion, there are some other causes of action from the state side, things like state unfair competition, passing off, contributory passing off, reverse passing off, and misappropriation, so things like counterfeiting and those kinds of things you can take a look at. Now, there are some defenses. If, let's say, you have a client that has been charged with trademark violation, one of the defenses is that the trademark is invalid, and this happens a lot when they try to prove that the original mark is generic or doesn't have enough strength to be protected through that. That maybe it was used in fair use, it was used descriptively and as an adjective, and therefore, it's not that they used it to identify that source, but to really say, relate it to it. Parody, if it is not used for commercial use, parody can be a defense. And then the other one is what we call nominal use. And here the court has said, and we have this case, New Kids on the Block from 1992, where the court says, if the use is so minute, right, it really doesn't affect, there's no harm to the original trademark owner, then we're not going to make a big claim about it, we're not going to make a big deal about it, okay? The other thing is, sometimes people would like to say, well, maybe there's a statute of limitations, meaning that there's a limited amount of time that you have in order to get your case in. And the truth is, there is no federal express statute of limitations for civil trademark infringement claim. But most federal courts would actually follow the state period. If the state has a statute of limitations, the federal courts will mainly follow that, okay? And usually For criminal, that's about 5 years. But the courts can also use the doctrine of latches to just determine that the claim is too untimely, too much time has passed, and you really have to get it in. Now, some remedies, the first remedy is always an injunction. It means to stop, to have that person stop using that mark so that they stop infringing or diluting the value of that trademark. There are some monetary relief that are available through 117A, and that can include the defendant's profits, what they got from using the mark, any damages that the plaintiff may have had, the cost of actually coming up to this, and then for trademark delusion, it's only about injunctive relief, so you want to be careful about that. One of the last issues I want to talk about is the Anticybersquatting Piracy Act. You have it here. This is basically some of the information that looks at, and it looks at domain names and social media account names and how a trademark can help you get the value of those or not. And the last thing I want to point out is the issue of a trade dress versus a trademark. A trade dress is essentially looking at an image or overall appearance, and it can include the features such as size, shape, color or color combination, texture, graphics, or even a particular sales technique. And this is the John Harlan case from 1983, and it's about, you know, looking at the look and feel. So some examples: the packaging for Wonder Bread, the Healthy Choice tray configuration frozen dinners, the Happy Meal box for children, the Coca-Cola bottle, and the front grille of the Rolls-Royce. So you have some examples here. Here's the Happy Meal box. Here's the IHOP, International House of Pancakes building, the Tiffany blue, and then here are some examples, Splenda and Vitamin Water, that sort of created some controversy. Okay, so we've done a lot talking about trademark, service mark, trade dress, what you can do with it, the registration process, and should you have any questions, just reach out to me. You have the email and the website there. Have a great day. Thank you.